It's Entertainment Law Update, episode number 182 for, what's today, July 23rd, 2025. Hello, everybody, and welcome to Entertainment Law Update from Los Angeles, California. I'm Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamera Bennett.
And we are so glad that you are here with us today. This is our podcast by entertainment lawyers about entertainment law, where each month we round up notable cases, news, and information to keep you informed and hopefully a little entertained. Now, we do welcome your feedback, suggestions, and input, so please do visit entertainmentlawupdate.com and use the voice widget on the side of the screen, or just send us an email at entertainmentlawupdate@gmail.com. Tamara, what's new with you?
Well, we're in the dog days of summer, and I'm trying to learn how to barbecue on a charcoal grill. That is all I have successfully done so far is open the beer.
Okay.
That is the extent of my 2 attempts of barbecuing
Arguably
or
the most
grilling.
important step in the process.
Grilling on charcoal. That is my summertime update, and then also to note that summertime in Texas is not the right time to start this new adventure.
Outdoor adventure. Yeah, exactly.
Anyway, what's new with you?
Well, sort of the same. Dog days of summer. Kids are doing their things with camps and swimming and archery and, the things that kids do in the summertime. And we're having a good time. But we had our air conditioning go out last weekend, and we've repaired it a couple of times, and I was really afraid it was going to be a complete replacement this time around, which, as you know, is an expensive adventure. But turned out it was just a little broken wire. So dodged
Very
a bullet
good
there.
news.
Anyway.
Yeah.
So anyway, well, we have a great episode ahead of us. And as you heard me mention before, we really do value feedback and suggestions and input. But and please, we really welcome it. But do be warned that giving feedback can have some real consequences, like being invited to join us on the show. And
That's right. And so, longtime listener, we are so happy to have Mikey Glazer join us. He's an LA-based transactional entertainment attorney. He's a self-described creator economy maximalist. And as I mentioned, he's a longtime fan of the show. He met Gordon some time ago. After one of Gordon's law school guest teaching spots, Mikey counsels talent reps throughout the legal ups and downs of onboarding and the breakups, which we all know happen, and he negotiates brand deals for YouTubers, podcasters, online creators, and the next-gen studios of our time. So welcome, Mikey. We are so glad to have you join us today.
I feel like I've jumped into my television or my podcast earbuds. I have been listening to you two for well over a decade. Gordon did speak teaching at our law school, but since then, I have memories of my child being very young and being at the park and having earbuds in, listening to you as he's playing in dirt. And Tamara, you unlocking a strategy, something you said that really unlocked something I was blocked on a client.
Oh.
And I was like furiously
Wow.
sending myself a note. I listen to you guys as I jog around LA in the mornings, and every sort of month, at the end of the month when Entertainment Law Update comes out, for a couple days, I have like a mental warm-up before a day of lawyering by listening to 1 or 2 segments of you guys per day, and it's like my mental warm-up before a long day of lawyering at this very desk. So thank you guys so much. I'm a little starstruck, and I hope I can be a worthy contribution here.
Well, we'll cure you of all that as you see the sausage being made here.
Yeah. So. Yes, you've already seen Tamara's lack of technical skills before we jumped on. So
you reached out to us to tell us about the new Fashion Workers Act in New York that I guess took effect in mid-June. Why don't you tell us a little bit about this new law?
Okay, so there's a new state law in New York that is called the New York Fashion Workers Act. And what this does, Gordon and Tamara, is this creates a new class of regulated talent representative in New York that is distinct from agent. So we now have 2 different classes of regulated talent representatives. And what it does is it now creates the most talent protective, least exploitive talent representation regime anywhere in the country, and that even knocks out California, that has had traditionally the most granular and most burdensome sort of, if you're a talent rep, um, representation regime. So before you reach for that fast forward button, if you're listening and you're like, I don't represent models and I don't practice in New York, I have to give you two reasons why this still matters to you. And you have to keep listening. The first one is because the New York Department of Labor, which is the executive branch that's going to be enforcing this law and writing the implementing regulations, has already come out and said this doesn't just apply to models. This can also apply to influencers and anyone else who's performing model-like conduct. So promotions, sponsorships, promotional models. We're not just talking about fashion runways. And the second reason why it definitely applies to you is because this also applies to anyone who hires models. So we're talking about the Walmarts, the Kohl's, the Targets. And what it does is it imposes SAG-like minimum working conditions that have employment standards for anyone who hires models by default. Normally in entertainment, we only see this kind of regulation and employment standards when an employer has chosen to become a SAG signatory. And now we have these sort of things that are happening by default. So let me quickly run through sort of what this law is and what it is. And also, I think it's going to become the model for many other states. Quick background is that only a couple states in the US have talent agency regulation. California, where Gordon and I are, Texas, where Tamera is, has sort of had it in process over a couple different years. It's different sort of levels. New York, Florida, New Jersey, North Carolina, Nevada, those are the states that actually have specific talent agency regulations on the books. A bunch of other states have just sort of general employment agency laws. But here's sort of the problem and why it's so sort of localized in New York. The modeling industry is predominantly fed by young women that work in this industry. They usually come from smaller markets around the country where they have what's called a mother agency, someone that's discovered them. And then once they've achieved a certain level of stature, they're sent to New York with a bigger agency like one you've heard of, like Wilhelmina or Next or Women or one of these other agencies. There is no union or trade organization for models. There's no SAG equivalent. There's no AFTRA. There's no WGA. Because New York is expensive and these women are generally very young, what these model agencies in New York do, and I'm using agency to describe even the ones that are not licensed, is they get these things called model apartments. And they will cram 6 or 8 women into an apartment that the agency owns. And then they live there and they charge them against their account to live there.
Company town.
So there's a lot of upfront costs. And that sort of also creates a power imbalance sometimes where the models become in debt to their agents because they're in New York for a couple months before they even start working at all. Another part of the power imbalance in this industry is that the clients, when I say clients here, I'm talking about the brands that hire talent. So in the traditional sense, we'd be talking about, Paramount or NBC or ABC or a show. But in the fashion world or in sort of the influencer world clients, we're going to talk about Taco Bell, Pizza Hut, Kohl's, Target, Gap. The relationship with the clients is really held by the representatives. They're the ones that really have it. When Target needs someone, they don't call the agent to say, we want Tamera. They say, we're looking for somebody like this. And then the agency will send, a book of like 30 people and they choose. And so a lot of the agents also have power of attorney. So a lot of the deals are made just directly by the representative and the client. And the talent finds out about it later. They might approve it, but they might approve it like over text or say, hey, do you want this gig with Target? It's going to pay $2,000 for the day. But a lot of this happens what we would call ex parte, right? And the paperwork, the model never sees, the terms they never see. And the other sort of part of this power imbalance is that much like the way that commercials work under SAG, models' fees are really bifurcated. There's a session fee. We need you to show up for 8 hours on this day and you're going to do, bathing suit, or you're going to do, I don't know, whatever the gear is. But then there's also a usage fee. And the usages are how we can use it, what media, what territory, what duration. And often those usages are then extended later. They come back and they want to upgrade or they want to extend. And what does the agent or rep do? Of course, they just say, yes,
Yeah.
free mailbox money, right? And so models get in this situation where they're, hey, why am I still on the side of that bus? Why am I still seeing myself in H&M 2 years later? They don't know because a lot of this stuff is transacted ex parte or they find out later. So there's the problem.
Mhm.
Are you still with me or have I bored everyone to death?
No, it's fascinating and
Okay.
great background. So
Yeah.
what does
So-
this new law do to address these problems?
Okay. So what they focus on in this new law, I'm going to talk about what it does to managers.
Mhm.
It imposes a whole laundry list now of duties and prohibitions on model management companies. And then again, think about this broader, just sort of beyond models. There is a 3-year hard cap, black line statutory limit on contract terms. You cannot have a contract longer than 3 years at all.
Mm.
You cannot have automatic renewals anymore. There has to be an affirmative from the talent opt-in to say, yes, I want to renew this agreement. And that's important because these relationships, like with talent, you sort of lose money in the beginning of it until you build them up and then you make it back. There is now a statutory fiduciary duty established,
Wow.
which used to be only the province of agents, literally like lowercase a agents
Mhm.
have a fiduciary duty. So that's really big because now you have breach of fiduciary duty claims, you have conflict of interest issues that come into play. What it also does, and a bunch of other things, it says like you have to give the model a written agreement for them to see 24 hours before they start shooting anything. They also have to give separate approval for anything that has to do with digital or AI. They have to disclose all of the terms like in writing to the model in advance. But here's where it really gets interesting. Traditionally, agents, at least in New York, there was no private right of action against your agent. If you had an issue, a dispute between your talent rep, you had to go to the New York AG or the Department of Labor and file a complaint and hope that they would do something
Mhm.
administratively. And in all my research, I have only found one case ever where they actually did anything. So for lawyers, listen up. This is the part where it gets really sort of dicey. There is now a private right of action that is created that allows you to sue your representative in court or the Department of Labor. And there is a 6-year statute of limitations. That is longer than a lot of bodily injury crimes in New York, and it includes attorney's fees. So people are going to pay attention to this and they're going to comply with the amount of overhead that this is going to create by having to really make it much more transparent as to how deals are done in this space. And for any sort of slip up to have, a 6-year statute of limitation attorney's fees, I think it's pretty severe. And here's why. Okay, all that preamble gets to why I think this is an interesting issue for entertainment law update listeners.
Mhm.
One of the duties it creates is, besides the fiduciary duty, best efforts to procure work for your talent. And I see Gordon furrowing his eyebrow because we all know that in talent representation, the bright line between agents and non-agents has always been procurement.
Mhm.
And so this in California and in New York and in any state that has sort of talent agency regulation, procurement is this bright line and it's a trigger for needing a license. Procurement is interpreted broadly.
Mhm.
That means if you are offering your clients, if you are submitting them, if you are getting in negotiations with them, you need a license to do so. And now this New York law, I think, has this unintended consequence of where it has basically legalized procurement for people that do not have a license. And to be very specific about this, and I'll put a clip in the show notes, we have conflicting laws now on the books in New York of equal authority, where one law, the New York General Business Law, says you cannot procure without a license. And we have this more recent law, the Fashion Workers Act, that says you have a fiduciary duty to procure.
If you don't have a license, you have to.
Yeah. So let me ask you a question then, Mikey. How does that apply then? Let's say I'm a recording artist for a label with corporate offices in New York, and they find me an opportunity that is maybe more along the lines of me modeling, but I'm not a model. Where does that line cross for
Well,
people
an
who are
athlete
in
with
the
with an endorsement kind of a deal or something, right?
with an endorsement deal, which might normally be something that the quote record the artist manager would procure. I'm just trying to see how far can this go? How far is the reach beyond what we consider a traditional person who is their lifeline is being a model?
So there's a definition, statutory definition of model. It's obviously it's somewhat more narrow than I expect it's going to be interpreted as, because
Okay.
the New York Department of Labor has already come out with their FAQ and expressly said, don't think this is just limited to models. And that's what really got my attention. They had an FAQ about like, what should we be doing? There's still in New York, the theatrical employment agent. So in your scenario, hypothetical, Tamara, it's possible that that recording artist has a licensed talent agent.
Okay.
And the talent agency lobby did very well in Albany because they got written into this law, in the first line of this law does not apply to licensed talent agents.
Got it.
Well, all of this burdensome sort of overhead and regulation, if you're a licensed talent agent in New York, you get to go, not us. And I represent a modeling agency that bucks the trend in New York. In New York forever, all of these talent representatives built their business on a fiction. They call themselves managers to avoid this procurement trap.
Mm.
And I represent agencies that I think do it the right way. They are classified as agents. So if you're an agent and you're licensed already by the state, you're immune from all of this stuff. And a key distinction, let's always bring it back to money. In New York, there is a statutory cap on commissions for agents, capital A agents, 10%. Under this new law, managers capped at 20%.
Wow.
So there's a 50% difference in revenue. So what I think actually is going to happen is a lot of the people that are agents that already have to go through this process. And now for this managers, just keep in mind, you have to register with the state as a manager. You have to pay a registration fee. You have to have your contract approved by the state. These are all the things that we're used to seeing for agency regulation. There's really no reason for you not to go, why don't we just renounce our agency licensure, become a manager and charge 20% instead of 10?
Hmm. It was
So how did they come up with sorry, Gordon, how did they come up with the 20%? Is that because they have cut out maybe the manager was getting 10% before and the talent agent was getting 10%? Does that make sense? Is that what happened?
A lot of these things in the modeling industry, or like in this specific industry and around New York, when I got into this about 10 years ago and really started focusing on this, the answer was that's the way the industry works.
Okay.
And I know that traditionally agent managers in New York take 20%. So I think they preserved that framework. And I think it was a surprise to many people that New York has a statutory cap on agents at 10. In California, we don't have a statutory cap at 20%, but the labor commissioner, which has long held, they will not approve anything over 20%. And that it's basically we have 20% cap.
And the unions step in and cap things too. You can't get franchised by the union if you're charging more than 10% most of the time.
And that's absolutely right too. SAG has this. So where I think this is really interesting here. So for lawyers, practitioners, is it might affect you even if you don't think it does, because you also can't offload these responsibilities through an intermediary like a production company if you're Kohl's or Target or whatever. So that's how it affects you. I also think it's really interesting that we have these two laws now of equal weight that seem to be in direct conflict as to whether procurement is allowed or not allowed. And I think there's sort of some sneaky winners and losers here. I actually think obviously a winner is plaintiffs' attorneys in New York that are going to look for opportunities to capitalize. This law came about also, it bears to be saying, by really the work of an advocate. This woman, Sarah Ziff, who is a former model who walked away from the industry and became an advocate for models and started this trade organization called the Model Alliance that is national. So if you're like in one of these other states like Florida or Tamara in the Dallas-Fort Worth Metroplex, New Jersey, Nevada, and you don't think this is going to come to your state, I think you're wrong, because Model Alliance is national, and they push this through the Albany legislature. So winner, plaintiff's attorney. I think sneaky loser of this is probably middle market talent, because these overhead costs are going to create so much more overhead to the workflow for agencies or managers that I think they're going to drop the bottom half of their rosters. I think they're just going to say, you're not making enough money with us. It's not worth the overhead and the liability exposure. And then they'll be unrepresented and exploited more. I actually think a sneaky winner, despite all these new overhead and regulatory requirements on contracts and registration and contract approval, is the management companies, because they can discard this fiction that they've been building their business on for years that we don't procure. There's now a law in the books that says I'm obligated to procure, and surely an obligation cannot be a prohibition. And then I'd say for licensed agencies, it's a little bit of a draw. They had really good lobbyists in Albany that got them excluded from this regulatory overhead. But for the same regulation overhead, they could be getting 20% instead of 10.
So I'm curious, two things. This is not a licensing law. This is not creating a talent manager's licensing scheme. It's sort of saying if you're operating without a license, these are the rules.
Well, actually, you have to be registered now. There will be a registry and a list. So it is.
Okay. And the next question is, does this potentially have lawyers getting caught up in the net of being defined as managers if they represent these kinds of folks?
I absolutely think it could. There is a California case from the Department of Labor Standards Enforcement, which is where you read all in California, where a very high-profile lawyer from a firm that we've all heard of, that is one of the sort of Beverly Hills boutique A-list firms, is a defendant himself for unlicensed procurement. So lawyers, we could absolutely get caught up in this if you are, negotiating sort of deals for clients that we have some exposure. Good point, Gordon.
Okay.
So you said this, Mikey, and I just want to I was thinking it as you're kind of giving us the rundown on this about the lower level, maybe even the entry level models, those women who are living 5, 6 to an apartment, they're not going to have the money to enforce their rights under this anyway. So do we really, eh, are these new management companies going to comply with them? If they don't cut them loose, do we really think they're gonna put together the required deal memos, tell them 24 hours ahead of time? I mean, I don't know.
Well,
What are the odds?
I think they will, because the statute includes attorney's fees.
Ah, okay.
So that's what raised my eyebrows
Okay.
on this. And I also think there could be unfair competition claims, because if you're not following the law, that's a predicate for unfair competition. And I'm pretty sure that unfair competition claim would also include attorney's fees. So there could be management company versus management company claims, especially because it's a fluid market and talent move from rep to rep. So if there's attorney's fees to be had, I assume that there's going to be an active litigation sort of economy.
And I did notice in some of the information you provided us, talking about these apartments, because that just caught my eye, is that now they're gonna get paid for that. They're gonna receive compensation to pay rent is how I understood it, but
I think it's more of a transparency issue. They will be advised in advance what they are being charged to live in the model apartment and how that sort of impacts their account with the model. Because that's really the hook when a model or a talent wants to leave. If they are in debt to their representative, it creates an inability for them to leave.
gosh, it sounds like the music industry.
I was going to say,
exactly right.
I was going to say it smacks of a human trafficking kind of a thing as well.
Yeah.
Look, I represent agencies and managers that I believe do it the right way. I think on net, this is clearing out some of the practices that I think gave the industry a bad reputation. And I think this is going to rightfully transfer the balance of power back to talent, where agent, lowercase a, and reps actually work for the benefit of the talent. And it's not this massive power imbalance. But I would say watch this space, because there's some other things coming up here that are really interesting. There's a class action lawsuit that has been certified as a class that I thought was going to be some sort of shyster plaintiff firm, but this is Quinn Emanuel. That's one of the premier white collar litigation firms, has a class action simultaneously going on against some of the model management companies in New York. It's specifically not the ones that are licensed as an agent, but these exact ones where they are asserting that the models are misclassified and that models are actually employees of the management firms that represent them. And I think that will be an earthquake to the industry if that is actually held. And then if you're interested in this kind of stuff, I nerd out about it. Obviously, you've listened to me talk about this way too long. I'm happy to nerd out with anyone else about it. I'll give Gordon and Tamara some links to other cases in action in this area in the show notes for this episode.
And you also provided some really interesting infographic material that we'll make sure gets into the show notes. And anybody who's interested can come on over to entertainmentlawupdate.com/182 to get the show notes for this episode. Mikey, thanks so much. This is really important information and valuable and an area that we don't often talk about on the show. So really glad to have had you reach out.
Guys, use that widget on the side of the website. It's an interactive format. You talk back. And I also would say, if you have questions, not just about Texas, but music or trademark, I've reached out to Tamara, an amazing resource. And check out Gordon's YouTube. Even just peer-to-peer, you want to learn about podcast law, forms. It is the way, Gordon, you articulate things that is clear, accessible to laymen. I watch your YouTube videos and I come away with new turns of phrase and ways to explain things. So you guys have given me so much free legal advice over the years. I'm just honored to be a very small part of this episode.
Well, thank you so much. And it's been
Thank you.
It's been great having you on the show. Hope to have you on again. So keep the tips coming.
Great. I'm going to stick around and learn about the HITS Act. So I'm going to get in the audience now.
All right. Okay. So let us move on with the show. And Mikey, I know you have to go at some point, so just feel free to drop off the call when you're ready. Tamara and I are going to just go about our business and continue on with the show. So
sounds good. Thank you again, Mikey.
Take care,
nice to actually meet you, even if it's still virtually. I love it. Thank you.
Fantastic. All right, I'm ready to listen.
Right on. Okay. Well, that was great. That was it's nice to have a fresh face and a new voice on the show to
It sure is.
break up the monotony. Well, let's talk.
Yeah, you're right. He's been corresponding and talking to us for a decade, and so it's just, anyway, it's delightful to have him on.
Yeah.
So
let's talk about this HITS Act.
You're
the one, you brought it to our attention for the rundown, so you want to take this one?
I will, and actually, I've been advocating for the HITS Act for multiple years. It's been in various forms proposed over many legislative sessions at Congress, and it's really to permit tax breaks for recording artists, musicians, small record labels. Until now, only Hollywood and Broadway could write off production cost up front. Record labels, recording artists had to write those off, amortize them over a number of years. The HITS Act, which is, I can't remember what the acronym is, but Help Independent Tracks Succeed, was actually included and passed as part of the Big Beautiful Bill. And it's a new law allowing music creators to immediately deduct up to $150,000 in recording expenses, which again levels that playing field with film, TV, and theater producers who have long had that kind of tax treatment under Section 181 of the Internal Revenue Code, which that was implemented in 2004 to stimulate domestic film and TV productions by allowing those costs to be written off in the same year in which they've been incurred. Music creators did not have that incentive. Again, as I mentioned, they had to amortize those costs over a number of years. But the HITS Act, which was pushed by the Recording Academy, AIM, and a broad collection of music advocates, has now been approved. So super excited. Like I said, I've been advocating as part of my work with the Recording Academy for a number of years to see this happen. There's also a number of other bills that have been proposed related to music tourism, curbing ticketing bots, supporting fair practices for the live event space, and a couple of things that we'll continue to watch. And I'll update over this next session when things get back into session for the music industry that I know the Recording Academy will be supporting. So I'll give you guys an update on that. But if you're a record label, independent artist, you can now write off that $150,000 this year for any recording cost in 2025.
And it's not just recording artists and labels, because as we got into it, John sort of thoughtfully asked the question, what about podcasters? Does this apply?
Okay.
And he went and looked at the code, and the section is broad enough that we think that it does in fact cover any kind of creator of audio, recorded content, basically. And so I think that podcasters, maybe even YouTubers, might be able to take advantage of this, and maybe that'll be a bit of a stimulus in that area to get people investing in some of these newer, sort of smaller YouTube studios that are starting up, and podcast companies and studios ought to be taking a look at it as well. I'm going to be diving into it more deeply and sharing that with the podcast community. As you know, I'm active in that arena, so that'll be
Well, and I love that because, if you want to spend a small amount or a larger amount in building out a studio or putting together a audio production of some sort, and then you talk to the CPA and you're like, "What do you mean I can't deduct all
Mhm.
that?" So I think part of it is we need to educate the CPAs and bookkeepers and accountants that this is now in existence. I'm glad those words just came out of my mouth. I'm going to be educating my CPA firm on this.
You're going to do a
Just
CLA, a CLE, or CLP, whatever.
yeah, CPE, I think
CPE,
that's
that's
what
what it
they
is. Yeah.
take.
Yeah.
But I have a couple of good friends, including my own accountant. I want to make sure they're aware of this and
That's
how
great.
it could potentially help their clients. So yeah, use it and make people aware.
Agreed. Well, listen, it wouldn't be an episode of Entertainment Law Update in the last couple of years if we didn't have the AI corner to talk about. AI and the law in the news. We had this past month, we had an important ruling, really just after we recorded our last episode. Meta winning an important ruling in its lawsuit where it is defending against the lawyers. This is the Cadre versus Meta Platforms case here in the Northern District of California. A big win. The judge recently dismissed a lawsuit brought by the authors. That was the Sarah Silverman, Ta-Nehisi Coates. They claimed that Meta used their copyrighted books, some allegedly pirated, to train its LLM, which is called Llama, AI model. But the court's reasoning came with a big caveat. The judge, Chabria, ruled that the authors simply didn't make a strong enough case. It wasn't so much a ruling on the issue, the question of the AI training, but so much more about the particulars of this case. He emphasized that the decision wasn't about whether AI training on copyrighted material itself is legal across the board, but more about whether these plaintiffs showed that Meta's use caused them real market harm. And in the judge's view, they didn't. So he sort of elevated the market harm, that fourth factor of the fair use, to give it, I guess, more importance in this instance. He leaned heavily on the idea that AI training is transformative, especially when the output doesn't resemble the original. That gave Meta the edge on fair use. And then again, it wasn't a sweeping endorsement of the training practices, but much more the authors just made the wrong arguments in this case. So that doesn't mean that AI companies necessarily have blanket permission for this kind of scraping. So along with that recent Anthropic ruling, which we'll be talking about in a moment, it shows that the courts are open to this idea that AI training might be fair use, but it's really going to be pretty fact dependent. One of the issues that was flagged in the Anthropic case was how the piracy in two similar matters in the same federal circuit decided days apart actually conflicted in how they were treated. The piracy in Anthropic being a factor finding against fair use, while in Cadre the piracy was essentially considered permissible because there was not enough evidence of market harm. So the door to future claims is still open. Just got to revise those arguments. This isn't...
Yeah.
Go ahead.
Well, I was going to say, when we say days apart, the
Yeah, the
The
Anthropic
Bart's
case,
case, the
yeah.
Anthropic case was published on June 23rd,
Mhm.
and the Meta case was on June 25th,
Yeah.
out of the same
Yeah.
circuit. So,
Um, yeah, right. So, actually, anyway, the point here really is that this is a very case specific victory founded on this insufficient proof of harm, not a sweeping endorsement of the way that this is happening, at least not yet. We're not seeing that sweeping endorsement. And the takeaway is, look, got to have firmer evidence of the harm to bring these cases forward. And let's talk a little more also about the Bart's versus Anthropic case. That was the one that we're talking about that was decided just before the previous. That one was Judge William Alsup issuing a what has been characterized as a Solomonic ruling. Um, that he basically saying that training of the Anthropic's model, the Claude model, on legally purchased books fell under fair use, and he described that as quintessentially transformative, comparable to what a writer does when learning from other authors to develop their own sort of unique voice. Not sure I buy that, but anyway. But he drew a clear line regarding content that was pirated. Anthropic had acquired and stored over 7 million pirated books that were sourced from various online pirated libraries like Library Genesis and Pirate Library Mirror. He said that doesn't qualify as fair use. And because of that pirated library issue, he rejected a summary judgment on those allegations and set trial for December of this year to answer the questions of liability and damages and so on. And given statutory penalties on a per book basis, it's possible it could run up into the billions of dollars in damages with 7 million potential uh, infringed works. Well, a little later on in July, just last week, the judge certified that lawsuit as a nationwide class action. So the three named authors, Andrea Bartz, Charles Graeber, and Kirk Wallace Johnson, are acting on behalf of all U.S. authors whose works may have been downloaded and used in Anthropic's system. And the argument that it would be impractical to identify all the affected authors that the Anthropic made it was rejected, just dismissed. Nope, we don't care if it's impractical. You gotta do it. So that's sort of where we are. I suspect that given the need now to communicate with all those potential plaintiffs and get them signed on board and ready for the trial on the class action, that December trial date is probably going to get pushed. At least that'd be my guess.
yeah, I can't imagine that would happen. I mean, and it's I don't know if this is a good analogy or not, but it feels a little reminiscent of the Flo and Eddie class action
Mm-hmm.
on the music industry side,
Yeah.
which I will tell you, I had clients who were in the
Mm-hmm.
class. I'm like, "What have we got to lose?"
Right.
And it worked out great for those clients. So, you know, if this is what happens, I would say if you represent someone, especially for the smaller, catalogs of books or authors, you don't know. It might be the only way to get the money out of the deal.
Yeah.
So,
Yeah.
is to be a part of that class.
Well, yeah. So anyway,
Yeah.
these are just two of the cases that are, moving their way through the courts relating to the AI, two of the first, real rulings we've seen. But it sort of seems like this piracy angle might take hold as an important turning point in how these cases are decided. And meanwhile, there's legislative action. Authors, including like David Baldacci, was pretty vocal. He has drawn some congressional attention by testifying about how the work imitates their work. The AIs imitate their work almost verbatim. And so we have bipartisan proposals, one of them which is called the TRAIN Act, TRAIN, designed to improve transparency and accountability in how these systems are trained. So that's pretty interesting.
I was just going to say this comparison that, by training the AI in all of these different works is the same as a writer would train themselves.
Yeah.
But I can't consume that many works. I mean, over a lifetime, how many books can I read? How many books can I listen to
Yeah.
versus it happening, with a snap of the finger for
Mhm.
a computer.
Well, yeah, I mean, I'm not sure that's I mean, yeah, you listen to the radio all the time, and if you end up accidentally or intentionally copying some song that you heard, remember George Harrison had that suit with the,
Right. Yeah.
My Sweet Lord or whatever, you know, but would that be would that naturally make it fair use? Oh, well, yeah, sure, he had access, but he absorbed it the way people do, and that was just a catchy. I don't think that plays, but it does seem to be what the courts are saying in these cases. So,
I
um,
guess I'm also looking at it as maybe as just a complete and total unfair advantage
yeah,
to technology versus the human creator.
absolutely, absolutely. Well, Texas has a new law addressing AI too, doesn't it?
Yeah, we do. So we just for folks who are outside of Texas or even folks in Texas
Hmm.
that don't realize this, we have it's not a biannual. I can't
Semi-annual,
remember
isn't it?
how. And well, it's every 2
Yeah.
years. So we have a legislative session every 2 years. We just concluded our legislative session, and obviously, if you're in Texas and watch TV, you know we are now in a special session for a
Mhm.
variety of different reasons. But one of the things that came out of the normal session was this passage of the new Texas Responsible Artificial Intelligence Governance Act, which is House Bill 149. It passed with bipartisan support, signed into law by the governor, and it is really designed to protect consumers while implementing expectations for businesses that are using AI. The act prohibits the development or deployment of any AI system for certain purposes, including by private sector entities that you have to be conducting business in Texas. If you produce a product or service used by Texas residents or develop or deploy an AI system within the state, the law takes effect in January 2026, which actually kind of caught my eye because most of our laws take effect in September of the same year, but this one is January of 26. Requires that companies using or developing AI consider its implications to the public and on the public, and have the following duties and prohibitions. You've got to have a disclosure to customers. A governmental agency that makes available an artificial intelligence system intended to interact with consumers shall disclose it to each customer. Manipulation of human behavior. Any AI system cannot be developed or deployed to intentionally encourage any person to physically harm themselves or others or engage in criminal activity. There's a social scoring component, a capture of biometric data, concern regarding governmental entities not being able to develop or deploy something that's going to capture that biometric data. There's our constitutional protections, protections for unlawful discrimination, and also a sexually explicit content protection where AI systems may not be developed or distributed for the sole intent of producing, assisting, aiding, producing, distributing child pornography or unlawful deep fakes, videos, or images. The act states that these prohibitions should be broadly construed and applied to promote the underlying purposes of the act, which is really facilitating responsible development of AI. And so I know I mentioned it earlier about advocating with the Recording Academy. I'm super excited to say that in February of this year, I was in the Capitol at Texas and able to advocate for the purposes of this really related to the deep fakes in the videos and how that impacts, creators. So, there is a Texas AI Council, and I thought that was interesting, went out to take a look.
Mhm.
It has 2 a senator and a representative, someone from the state, and then academics and professionals that are part of that council for the government oversight.
Wow, very interesting. One of the things that caught my eye and I raised my eyebrow about is the sexually explicit content component because if I recall correctly, one of the federal laws, a Child Protection Act of, I don't remember if it was COPPA or COPA or one of those, but didn't it fall on constitutional grounds because it was too broad because it addressed artificial child pornography where there were no
Mm.
actual children involved? And isn't this deep fake
That
thing?
is that is sounding familiar, but distributing child pornography or unlawful deepfake videos.
Unlawful. So that, I guess it would have to be real people, right? Well, deep fake of a real person, not just a fake, an
Yes.
artificial character or something. Okay, that makes some sense.
I think that's where we've really got I've got a summary here, but where maybe the law is going to be if it's
Mhm.
challenged is what do these words mean? Is that an and or an or?
Right.
Is it one or the other or a combination of the two is probably what we're gonna see happen. So also, just to add that the federal government's quote, One Big Beautiful Bill Act prevents nationwide legislation on artificial intelligence for the next 10 years, but states do have the authority to enact whatever oversight measures they would like. 45 states, Puerto Rico, Virgin Islands, DC, have all introduced AI bills in 2024, and 31 states, and also Puerto Rico and the Virgin Islands, have adopted resolutions or enacted legislations or states have created task force, and I know there's been a lot of activity in California as well.
Yeah, our governor vetoed a similar law late last year. I think probably in response to a pretty strong tech lobby in Silicon Valley and so on. But I think given the texture of how things have been with the California legislature, it won't be the last that we hear of this, and there will be more
Yeah.
attempts to do this. So, um, well, okay, yeah. So anyway, that's the patchwork of state laws coming into play now that the federal has the moratorium on these kinds of laws. So that'll be interesting. We'll have something to talk about for quite some time.
Yeah. Yeah, and my recollection is just on the Texas. I actually don't think that deep fake portion it may have been kinda separate, and then
Yeah,
all of that kinda came together as one piece of legislation where
yeah.
it was, I
Part of
think,
the horse trading
multiple
that goes on to make laws like
Yeah,
that.
yeah, there were kinda multiple proposals over the legislative session, very much like what happens at the federal
Sure,
level.
sure. All right. Well, continuing on in the AI arena, in early 2023, as you may know, Getty Images had filed a copyright infringement suit against Stability AI, bringing claims under the UK Copyright Designs and Patents Act. And those claims were primary infringement by copying during the training and development stage, as well as primary infringement by authorizing copying by end users or communicating to the public at the output stage, and a secondary infringement by importation, possession, and or distribution of an article which is itself an infringing copy. Well, on June 25th, so right after our last episode dropped, Getty Images withdrew their two primary infringement claims, as discovery indicated that the actual training of Stability's AI models happened outside the UK. So the courts just wouldn't have had jurisdiction over that, or
Mm.
at least that was the concern. So instead of spending time and money arguing for those two infringement claims that would likely be unsuccessful, the legal team for Getty decided to focus their efforts on the secondary infringement claim, particularly the reproduction of Getty watermarks in the output from Stability's tools. Now, Stability contends that Getty's remaining claims really stretch existing legal definitions beyond their intended scope. The company argues that a trained model like Stable Diffusion isn't an article in the traditional sense under Copyright Designs and Patents Act, and so it can't be treated as an infringing copy. And they also assert that there is insufficient evidence that the model reproduces protected elements of Getty's images in a way that constitutes actionable infringement. So judgment is expected later in this year, and the case is poised to set a sort of pivotal precedent on how UK intellectual property law applies in these generative models and cross-border data use and so on and so forth. So that's pretty interesting.
Yeah, yeah.
Yeah, I mean, we'll see. We'll see. It's the concern about the logo, because Getty does that watermarked imprint on its public-facing stuff. I don't know. Maybe there's a trademark-like claim in there if the system reproduces those as well.
So, right, so it's interesting. So in this set of facts, the Getty watermark, which we would call well, obviously it's a watermark, but in the US, we would probably refer to it also as copyright management information.
Right.
It remained.
Hmm.
So they're suing because or claiming because it remained on there, there was an issue.
Yeah.
Whereas again, in the US, had that remained, it knocks out making any DMCA claim for removing copyright management information, but if it wasn't there, so it's like,
Yeah.
you really, well, sometimes we do argue out of both sides of our mouth, but
But yeah, but it seems to me that if these systems are outputting that design, that logo as part of an image that the system is generating, isn't that a false designation of origin kind of a
I
thing?
think it is.
Yeah.
I think it's a
So
trademark claim, and I'm not familiar enough with UK trademark law to know how that
I imagine it's
plays out.
yeah. I
Yeah,
mean,
it's
it's
I'm
not an
assuming
issue
it's
in this
similar.
case, but yeah.
Yeah.
So well, we've talked about this case before. Que sera, sera, whatever will be, will
Sirrah.
be. Livingston versus Jay Livingston Music. You want to take this one?
I will. So we've talked about it, I think more than 2 times, but at
Mhm.
least in episodes 166 and 182. I'm gonna give you the quick summation that we did at the end of the year and then kinda dive into what's maybe a little more backstory on what's
Sure.
happening today. Jay Livingston is the author of the composition Que Sera, Sera, Mona Lisa, and many other famous big hits. His granddaughter sued her own mother, who is the daughter of Jay Livingston, for exercising copyright termination rights in Que Sera, Sera, and other popular songs. This is all the backstory. The court granted the defendant's motion to dismiss in both cases. In the first case, the court found that the plaintiff's claims were subject to binding arbitration clauses. Again, these are the granddaughter's cases. And in the second case, the court determined that the granddaughter's claims were invalid under Section 203 of the Copyright Act of 1976. The court's decisions were based on the facts alleged in the complaints and the applicable law, including an arbitration provision in certain agreements that had been signed and the provision of the lower courts. So these lower court decisions were appealed up to the Sixth Circuit, and that's what we're talking about today. Again, it involves a dispute between Tammy Livingston, who is the granddaughter of the songwriter, and his own daughter,
Traveling.
Travelin
Yeah.
Travelin Livingston, regarding really a family dispute over regaining copyrights through termination and maintaining royalty streams. Tammy, the granddaughter, is the co-trustee and beneficiary of the Livingston Music Interest Trust. The defendants, appellees, are Jay Livingston Music, a Tennessee corporation that owns Jay's publishing rights, his daughter, Travelin Livingston, who is the sole owner of that company. So backing up further, between 1984 and 2000, while Jay was living, he assigned the copyrights of 200 compositions into this entity, Jay Livingston Music, which he did not have an ownership interest in. It was solely owned, at least by 2000, by his daughter. In 1985, Jay and his wife created a trust, which is not out of the ordinary for songwriters, creators, even just other individuals, but it's really part of an estate plan. Uh, Travelin and Tammy were named as beneficiaries of this trust, but there was some ambiguity as to what assets were in the trust related to the musical compositions. Was it the royalty stream or was it the copyrights themselves? After he passed in 2001, there was a probate action. The parties submitted the matter to probate in California court, and the court issued a final order stating the family trust had no ownership in the copyrights, confirming that Jay Livingston Music Inc. was the sole owner, that the deals were done, everybody was represented and signed off. So, assets are held in the entity, structure of the trust, it sounds like some of the royalties were pouring into the trust. And then in 2015, um, Travelin, who is Jay's
Daughter.
daughter,
Mhm.
s obviously his wife had deceased.
Mhm.
Travelin being the only daughter, the only heir, only child,
Yeah.
served termination notices under 17 USC of the 203 of the Copyright Act, asserting she's Jay's sole heir, and she could terminate his prior grants to the publishing company and reclaim control of the compositions. It was for 32 different compositions with effective dates of termination between 2019 and 2023. The granddaughter, who by this act has been cut off of the royalty stream, sued in federal court, saying the termination notices were invalid, claiming the 2020 amendment to the copyright agreements were enforceable because of Jay signing in his capacity as a trustee, whether the original assignments were self assignments. So Jay was assigning from himself into something he completely controlled, that she should retain rights to royalties under state law, even if the terminations were valid, and that the 2003 probate judgment precluded her claims under res judicata and issue preclusion. The district court dismissed the granddaughter Tammy's claims under 12b-6. She appealed. We're here today, the Sixth Circuit. Uh, is Tammy's claim precluded by the 2003 California probate judgment? The court said yes. It clearly stated in that judgment the family trust had no ownership interest in Jay's copyrights. Same parties, same topic. You can't bring it up again. She also was represented by counsel, consented to the order that was issued in the probate ruling. The year 2000 amendment, it was not invalid. So Jay signed that both in his capacity as a trustee and as an individual as the author. So the grant was therefore valid. Jay was not an owner of the publishing company, and so that grant could be terminated by his surviving heir under Section 203. I think that's a great practice pointer. People need to be signing the rights in their individual capacity if you want the ability to terminate those. Again, not a self-assignment where the termination notice is defective, and I know that's an area we really talked about last year,
Mhm.
was to say the notices were valid, they weren't defective. She raised no issue as to that was valid, and so that was dismissed under a 12b-6 ruling, and she doesn't have any rights for termination, the granddaughter. Um, Takeaways, I would say for me, the takeaways are under the federal copyright grant. It's again, we know it applies to grants from the author to a third party.
Mhm.
This is saying, and I don't know if we have other decisions saying this, even though it makes complete sense. You're not going to circumvent this by granting it to yourself,
Yeah.
the termination rights. Uh, Obviously, you need to comply with the notices requirements under the Copyright Act, but this is a factor or takeaway that I kinda added to the summary we had. What termination notices can undo the estate plan, effective termination notices, and so estate planning attorneys, tax attorneys who represent these copyright creators, big estates, small estates, you need to talk to copyright lawyers who understand the impact of terminations on copyright grants. Um, that to me, I think, is one of the biggest takeaways.
Yeah.
And we've talked about this multiple times as we talk about termination cases. I don't know what Jay Livingston his intent was.
Well, you know,
Was it to share the money equally between his daughter and granddaughter? He put it into trust like that, but
yeah. Well, I'm not an estate. I don't know enough about estate planning to know, but it seems to me that if you're going to do that, maybe the answer is to also put into the will a clear expression of the intention, no matter whether the trust remains, those kinds of things, just so that there's some guidance for courts in this situation.
well, and I think you've gotta make that grant via the will,
Yeah.
and that might there is a section in the clause that you can make. It has to be the transfer is not agreeable. It doesn't you if it's a termination other than by will.
Yeah.
So if the transfer is by will, but that doesn't make good during the lifetime estate planning. There's
Right.
reasons they do that during the lifetime. So,
Hmm.
I don't know if it's a belt and suspenders kinda
Yeah.
thing. I think it needs to be one or the other. or
Yeah.
these will continue to be challenged, and that kinda defeats the during the lifetime. But again, he didn't transfer the copyrights into the trust during the lifetime. That court decision was made. He only transferred the revenue stream.
Right. Yeah. Hmm. Well, and
So
I find it troubling that uh, an estate plan could be dismantled just because of a wrinkle in
Oh.
copyright law.
Oh, it is all the time. I love talking just like Mikey likes to talk
Yeah.
talk
Yeah.
about the talent and artists and management or, actors and models, I love to talk about this. So if people wanna talk about it because we have plenty of cases where the estate plan is completely undone, through
Yeah.
the termination provisions of the Copyright Act.
Yeah.
So
Well, let's move on. We have another story. This is a trademark case involving members of the girl group JADE. And the case is captioned Reed versus Marshall. It's a Fifth Circuit Court of Appeals case. The plaintiff appellant is Di Reed, a founding member of this 1990s R&B group JADE. And the defendants and appellees are Joy Marshall and Tanya Harris, also founding members of the group. Also, Mira C. Holloway, a singer hired by Marshall and Harris to perform as part of the group, is also named. In 2019, all three founding members registered the JADE trademark with the U.S. Patent and Trademark Office as equal co-owners. And sometime later, there was a failed reunion attempt, and Marshall and Harris then hired Holloway to perform as part of the group without Reed. Promoters used Reed's name, image, and historical voice in the advertising of the concerts, and although she didn't perform and had not consented to that use. So she sued, alleging that the defendants had misled the public into thinking that she was affiliated with these new performances and that therefore infringed on her rights. She presented issues of trademark infringement under the Lanham Act, false designation of origin and false advertising, trademark dilution, both federal and state, and also Texas state law claims of right of publicity, unfair competition, as well as some issues relating to standing under the Lanham Act came up and the scope of co-owner trademark rights. And the outcome, well, the legal arguments. Although she was a co-owner, she didn't authorize the inclusion of a new member. That was one of her arguments. Promoters used her identity without consent, and that caused public confusion. This was misleading audiences and diluting the goodwill associated with the brand, and that it damaged her earning potential and reputation because of this perceived affiliation with this unauthorized version of the group's performances. The defendants took the other view, of course, as co-owners of the trademark, each had equal rights to use the JADE name. Holloway's use was lawfully licensed by the two co-owners. There was no contractual restriction on usage rights among the co-owners. I think that's an important note to flag. And that Reed lacked standing under the Lanham Act because she suffered no concrete commercial harm. So at the district court, the Southern District in Texas, granted summary judgment in the defendant's favor, held that the co-owners cannot infringe a mark that they are co-owners of, found that Holloway's use was under a valid license from those two co-owners, dismissed the false advertising claims for lack of standing, declined jurisdiction over the state claims, and up it goes on appeal. Reed challenging the legal rationale and wants reversal. So the Fifth Circuit affirms the district court on all of the federal claims, saying that a co-owner of a trademark can't be liable for infringement unless there is a contractual limitation on that. Trademark rights are non-exclusive among co-owners unless there's an agreement that says otherwise. And they cited a bunch of precedents: Moreno versus Pro Boxing Supplies from 2017, Bell versus Streetwise Records going back to 1985, Picari versus GTLO LLC going back to 2015, saying basically co-owners inherently have equal authority to use the mark and therefore there was no infringement. On the false advertising and designations of origin, the court looked at Lexmark versus Static Control Components and found that the plaintiff has to show a commercial injury directly caused by the deception. And the Fifth Circuit found that Reed had provided no such evidence of lost income or bookings or customer confusion. No consumer deception was demonstrated, and Reed was not billed as a performer, therefore not misleading anybody there. and that Reed lacked standing under both Article 3 and Lanham Act statutory requirements. Similar outcome on the dilution. The JADE trademark didn't meet the fame threshold for dilution, and the state law claim was dismissed for lack of supplemental jurisdiction because the federal claims failed. And the licensee question, said that the licensee, Holloway, acting under authorization from any co-owner, not an infringement. Holloway's performances under Marshall and Harris's authority were not unlawful. So there's the rule. If you're a co-owner of a trademark, you can't sue your co-owners unless you have a contractual limitation. Go ahead. What were you going to say?
Yeah, well, and I was just going to say another kind of practice pointer, or even though I don't know that this was a direct statement from the court, but as to co-owners, yes, I can grant a right, but I can't grant an exclusive license to use the trademark unless everyone agrees.
Right.
So I think that's one takeaway there. The other is just a understanding, and the court brings this out at the very beginning of their opinion. The Lanham Act is not designed to protect trademark owners or co-owners.
Right.
The Lanham Act is a consumer protection law. It's designed to protect consumers. So it really just isn't the right cause of action between co-owners.
Right.
Again, I think it's contract law. Was there a verbal contract, if there was no written contract, that limited the rights from between these different owners? Now, I didn't go and look at when, if their current registration at the USPTO if they have a current live registration, when the next maintenance filing is due, because I've seen this over and over again when it's filed with, 2 or 3 individual owners or as partners in a partnership. If everybody doesn't come to the table and make the maintenance filings, one of them can't do it. So they could potentially lose their federal trademark registration if they don't all come together to sign and file the maintenance filings.
Yeah. So that's another interesting wrinkle. Well, I mean, I guess, yeah. I was going to say, it sounds like in this instance, there was no dissolution agreement. There was no formal transaction when Reed was leaving the band under whatever the circumstances were that she left the group. It sounds like they weren't exactly friendly circumstances. But that would have been the solution, right? Is to grant who gets control over this brand, maybe even an assignment of the trademark, something like that. And that would have solved this problem. But, it's interesting that this ruling sort of complicates the issues when you get into this situation where a former band member is using the name in their solo career. Formerly, we've seen a number of those cases where someone sort of took off from the group and kept using the name to help promote it. And
and there's Pennsylvania, New Jersey, somewhere on the East Coast that actually has that state law that it has to be so many members of the existing group.
It was Shana Na was one of the cases, and it was New Jersey law, maybe.
Yeah. So we just, again, this was filed in Texas. Yeah. We don't have that. I didn't dive into the misrepresentation state law arguments.
Yeah, well,
just because it seemed they probably didn't even need to go there. They just needed to make a decision on the Lanham Act and trademark side of it and move on. So, but anyway, that's practice pointer. If you've got people in a band, business owners, really contemplate how you are filing that trademark application as to who really, you don't want to file it falsely. You want to name the correct owners. We want to make sure of that, but it may need to be put into a business entity that has some continuity and then spells out what's going to happen on dissolution.
Honestly, band agreement or band LLC or corporation or something like that is an important way to make this kind of work. Then you have issues about the work made for hire and other things that affect those.
Oh, yeah. So we're talking trademark separate from copyrights.
Yes. Yeah, no, but it's just, it's a patchwork of things you have to really think about as you're figuring out how these bands will operate. And if you're practicing in the music transactional space, this is definitely something to remember. So, Well, we have one more just quick final note for you. We've talked about the Cox dispute over that massive, what was $1 billion copyright infringement judgment for contributory infringement that was against Cox. They have now taken the case up on appeal, and I don't remember who was who in this. I think the appellate court overturned the jury verdict, and so now it's up on appeal. No, I'm sorry. I got it backwards. The appellate court affirmed, and now Cox is taking it up to the Supreme Court. It was a Fourth Circuit ruling, and the issue at question is whether that circuit erred in holding that the service provider can be held liable for material contribution to copyright infringement merely because it knew that people were using their accounts to infringe and didn't terminate their access without proof that there was, an affirmative fostering infringement kind of thing going on. So the Supreme Court has granted cert in the case, and that'll give us something to talk about in a year or two.
This time next year, maybe.
Probably.
Yeah.
So, and that does bring us to the end of this episode of Entertainment Law Update. As always, I want to say a big thank you to you, our loyal listeners, for joining us and spending your time with us. And please do, as Mikey said, give us your feedback. Head on over to entertainmentlawupdate.com and use the little widget on the side of the screen, or email entertainmentlawupdate@gmail.com, or find us on social media. Tamera, how can folks find you?
Yeah, on most social media sites, I'm at Tamera Bennett, TamerAbennett. On the web, you can find me at my, hard to believe, 7 months at my new law firm. Super excited. You can find me at harperbates.com or createprotect.com.
And I am Gordon Firemark. I'm in Los Angeles, and my website, firemark.com. gfiremark@firemark.com is the best way to send me email. On social media, mostly gfiremark is the place. And let's say thank you to our crack team. Volunteer contributors: John Janasek is our managing editor, Charles Thorne, Alexis Allen, Violet Zhang, Dawson Holder, and Lelwa Massetti all contributed to this episode. And if you are interested in joining the fun and being a part of this little family of contributors we've got, it's a pretty light duty kind of an undertaking, and we hope you'll consider joining us. Reach out. entertainmentlawupdate@gmail.com is the email address to send that. Send a cover letter and a little resume, and we'll be in touch. And with that, we'll wrap up this episode of Entertainment Law Update. Thank you again for listening. And until next time, hey, let's show biz.